Hi, everyone, and welcome to our presentation on cybersecurity and data privacy. So I'm Jordan Fischer, and I have with me my business partner, Rebecca Rakoski, and we are co-founders and managing partners of XPAN Law Group. And today, we're going to talk through the impact of COVID-19 and how it's being addressed from a cybersecurity and privacy matter. So thinking way back in March, which feels like potentially an eternity ago, the big question is this pandemic going to lead to more cyber attacks? And I think sitting here right now, we have seen a huge impact technologically from the pandemic on cybersecurity and data privacy. And in fact, we see a number of different organizations, the FBI, the FTC, that are putting out announcements that cybersecurity is a real concern. And so we see here that the FBI anticipates a rise in business email compromises. We've seen a lot of scamming going on using the pandemic and coronavirus as a way to infiltrate into a system. So one of the things we have seen across the board is using things that look like government emails, look like government actors who are providing links to helpful resources, links to things like your PPP loan, links to other things, how you can receive federal funding, et cetera, and then using that to infiltrate a system and download ransomware into that. And additionally, the FTC is also putting out information regarding coronavirus and the scams that are taking place during this time. And so we have seen this huge uptick in cybersecurity. It's been impacting a variety of industries, mostly the financial industries and the healthcare industries, because they're dealing with such sensitive issues around this time. They have been top contenders. And so we have seen multiple attacks against hospitals that are providing care under COVID-19. We've also seen a number of attempts to infiltrate banking institutions because they're involved in providing that loan information and ensuring that people have the financials that they need in order to get through this virus. So it's pretty clear that security and privacy are really this core thing that we've been focusing on. And so today, we're going to break this down and we're going to look at the various key aspects that are impacted, the key areas that are impacted by the coronavirus. And so we're going to take a look at some regulatory impacts that we have seen and the regulatory governmental approach and guidance that is out there, both in the United States and in the European Union. We're going to look at things that you should be aware of in your contracts and agreements. We're going to talk through the technological infrastructure impact and the fact that so many organizations had to spin up these remote environments. And then finally end with documentation and training. And it's really around this concept of risk mitigation and how do we mitigate risk. In all cyber and privacy pre-COVID, it was all about how do we get down to the lowest risk we can possibly do or the lowest risk we're willing to accept. And that risk profile, those threats and the increasing in risk has changed drastically in the last 6 months. So understanding the new threats to your systems, both from a privacy and cybersecurity perspective, are really key when you're trying to address those within your systems and stand up the most secure environment. So I'm going to turn it over to Rebecca to talk through some of the regulatory aspects that we have been.
So thanks, Jordan. I'm Rebecca Rakoski. I'm a co-founder and managing partner at XPAN, along with Jordan Fischer. And yeah, I know everyone is super excited to talk regulation. But considering we're in the financial area, it's something that everyone is very familiar with. And so it's always nice to talk to an audience where I'm not educating completely on how to comply with a regulation. Everyone here knows knows they exist, and your organizations probably have some sort of plan in place to deal with regulation. However, one of the things that we see a lot of are new regulations. And while New York Department of Financial Services Cyber Regulation 500 is far from new, I think a lot of organizations are still trying to address it. And we're going to talk a little bit about some of the more recent fine, or the most recent fine issued by the Department of Financial Services, NYDFS, in a moment. But you know, another area that we see a lot of intensity on right now is within the health insurance or the health area with the Health Insurance Portability and Accountability Act, or HIPAA. We also have you know, international regulations like the EU's GDPR, the General Data Protection Regulation, And we have now have the CCPA, the California Consumer Privacy Act of 2018, which I like to joke is out of the country of California, because California always tends to lead the way domestically in terms of laws and regulations. And what you see in California tends to migrate across the country, if you will, and impact other states as well and influence other states. And we're already starting to see that. But all of these regulations are in play right now, and I know that we're going to talk a little bit about the living in what I call as PC or post-COVID. That a lot of organizations thought that these types of regulations were not going to be as impactful as they were BC or before COVID, because they thought that the regulatory bodies that are enforcing these were going to let companies kind of slide, right? We're all dealing with this pandemic and we're all having these issues. But the reality of it is all of these laws are in full force of an effect. All of these laws are being enforced by the various regulatory bodies that are required to enforce them. They, particularly in the financial sector, where you have something like NYDFS, it is critically important for organizations to be complying with the laws, to embrace it in terms of it being a privacy and security by design type framework, and really consider the fact that just because you're impacted by one of these laws does not necessarily give you a free pass. It's really critically important that you are cross-mapping to all of these regulations, because different data points are going to be impacted by different pieces of different laws, and they're all going to be done differently. So it's really important, particularly because we also see that there is potentially new federal privacy legislation on the horizon. Now, for those of you who follow privacy laws the way we do, you will know that federal privacy law is nothing new, that in fact they have been trying to pass some form of it for a while now. However, what's really interesting is that in this post-COVID environment, it seems as though the federal government has decided that privacy is really important. They're a little late to the party, as we all in this area, we all know privacy is really important. But they are definitely proposing new pieces of legislation. Currently there was a piece of legislation proposed by a group of Republican senators, I believe, and it seems to have some legs. And so we'll see how it goes. Obviously, there's an election coming up, and we're not going to get into that, but it's kind of a roll of the dice as to what's going to happen at the federal level. But be aware that on both sides of the aisle, Republicans, Democrats, independents, everybody sees privacy as really the new up-and-coming area that needs to be addressed at the federal level. So really, really important. Some of the things that I would tell you in terms of these regulations and the way that we see them being impactful, in particular in the financial sector, is that the NYDFS issued their first cyber abuse, or they started their first regulatory action under NYDFS against First American, which is not a bank, but it is an insurance company. And the investigation was as a result of a data breach. What's really interesting about NYDFS is that for each alleged violation, the organization has potentially a $1,000 fine per violation. And the way NYDFS is interpreting that in this instance is for each piece of data, each piece of private information that was exposed as a result of First American's alleged deficiency in complying with NYDFS cyber reg, that is an independent action subject to a fine. And so it can get, it's probably going to get very expensive for First American in terms of just regulatory, just from New York. First American has customers all over the country, so they are not just dealing with, with New York's regulatory scheme, but New York NYDFS did issue their first action related to cyber abuses. The other thing is what you're seeing is that with everything going on right now, with COVID, with politics, it's all the noise that is happening. What tends to constantly be bubbling to the surface is the fact that security and privacy are hotter than ever. They are absolutely top of mind. I read article after article about CEOs. This is the one issue that keeps them up at night. This is the number one worry that they have, and they should be, because of things like First American, because of things like data breaches that we are seeing, because of the regulatory fines that are basically if you are found to be deficient, it's a per se violation. We don't even get to the part where we're talking about lawsuits brought by individuals. So this is a huge area. It is not going anywhere anytime soon, and it's something that organizations really need to be laser focused on, if nothing else but to alleviate the sleep deprivation that it's causing for some of the C-suite. And what we see is, again, in literally every sector, and for every law that is on the books right now that relates to privacy and security, PC, again, post-COVID, we see that the officials, the regulatory bodies, the regulators who are required to enforce these laws came out and basically said, hey, for those of you who thought this is going to be a non-issue PC, no, it is an issue. In fact, the Office of Civil Rights, which is the body that is required to, or that is empowered to enforce HIPAA, said that the privacy rule is not set aside during an emergency. You saw statements from the EDPB, the European Data Protection Board, which basically came out and said, in times like these, our privacy and the protections around personal data are more important now than ever. These organizations, these regulators are not backing down, far from it. We see, again, they're doubling down on COVID guidance. They're providing a lot of information for companies that have to comply. We actually just recently saw some guidelines that the EDPB put out relative to processor, sub-processor, joint processor, that type of thing. But we're getting more and more guidance. And the more and more guidance we get, the clearer it is that these regulatory authorities are not shying away from issuing fines during COVID. Sorry, got a little excited and clicked a little too far. The other thing is you look and you see that they are focused, missile lock focused on the healthcare industry with some of these. But that is not to say that they are not concerned about every aspect of data privacy. And certainly, for those of us that work regularly in the financial sector and the financial industry, having a real awareness of these data privacy laws is critical. Jordan's going to talk a little bit about the CCPA and its effect with regard to the data collected by banks. And as many of you know, that there are some certain carve-outs under CCPA. But just because there are carve-outs related to certain data does not necessarily mean that it's a carve-out of all data. And so there's a little bit of coming attraction for you all. Every single time the EDPB has spoken PC, we have seen them take the position that data protection laws are in effect, that they are being enforced, and in fact, we have seen additional enforcement actions out of Europe. So it is really critical that organizations at every level, in every sector, but particularly in areas like the financial sector, like the healthcare sector, where we are seeing more and more potential threats pop up. And Jordan was speaking about them a little while ago. We saw a huge uptick in ransomware PC. We saw a huge uptick in phishing emails and things like that. I mean, they went up like, I want to say 160% when everything went, post-March, because people are at home and these hackers are banking on the fact that we're not paying as close attention. Well, part and parcel of us not paying close attention is if we click on a link or we are subject to ransomware, and the organization we work for is subject to ransomware, that it is critical that we recognize that because these hacking incidents are affecting the organization, that they are also going to draw in regulatory enforcement action. And the last thing I would point out, and I know Jordan is going to talk about this in just a moment, but the Attorney General in California also came out and stated back in April that, it's CCPA more important than ever. Again, we see over and over again these regulatory authorities coming out and talking about the importance of data privacy. We see movement at the federal level with a piece of federal legislation related to data privacy. So for those organizations that are considering pulling back, now is not the time, because obviously the threats are increased and the concerns related to regulatory actions are heightened now more than ever. And with that, I am going to turn it back over to my partner, Jordan.
And so one last sort of highlight from a regulatory perspective is from OSHA. And this really impacts the way we're viewing privacy. So as more and more organizations are going back to work, and especially in the banking area where you have individuals who are going to be doing frontward-facing, customer-facing work, the question becomes where can you and how much information can you collect on those individuals? And we see guidance out of Europe on this, and you might be thinking, why did Rebecca talk about Europe and why did we bring that in? And it's because they do have a privacy law and they do have enforcing mechanisms. So Rebecca, thank you. And so the OSHA guidance around employees is that privacy needs to be considered even in this current environment. So yes, you want to know if your employee has had exposure to COVID-19. Yes, you want to mitigate the risk of your employees bringing COVID into your workforce, and then also your employees getting COVID at your workforce. I mean, any exposure to this disease creates both personal risk and business risk. But when addressing those concerns, privacy needs to be included. And that's not something that's going to be carved out under the typical financial regulatory exceptions that you see in regulations like the California Consumer Privacy Act, because that's dealing with employee privacy data, that's dealing with healthcare data, and that's dealing with very highly sensitive information. And so you need to be thinking as you start to put in place return to work plans, or as you start to take the time to look at what those plans look like, you need to step back and say, are we addressing privacy? Are we including privacy within this regulation? Or within our approach, because the regulations, as Rebecca has shown, really are still in play. And they have made it clear across the board in California, federally from HIPAA, internationally from the GDPR, that yes, this is a time of crisis. Yes, this is a time of extreme change, but none of that negates privacy rights. So when you're looking at this, how should you be focusing on your technological infrastructure? And you really want to be looking at a few key areas. The first is, for many companies, remote work was not something that was necessarily in place beforehand. And especially in the financial industry, historically and traditionally, remote work has been limited. It's often much more in startup incubator environments that there is remote work. And most times employees are required to be in the office, both in the back end and also in the front end. I was actually talking to someone the other day and they said, wouldn't it be interesting if we could start to have bank tellers that interface over a computer screen? So you would actually just walk in and you'd see a computer screen and the bank teller might be at home doing work remotely. I don't think we're there yet, and I think that there's a lot of innovation to be had around that. But the point being that when we spun up these remote environments very quickly to allow our employees to be working remotely, we needed to take into consideration privacy and cybersecurity. And now is really the time to be thinking about how you can harness these environments that you had to very quickly create to actually improve the business. So one thing to be focusing on is device management. And what devices are you providing to your employees? How are you securing those devices? How are you ensuring that only the employee is using the device in a way that you are comfortable with? The other area to look at is virtual private networks. I think a huge concern, especially in the banking industry, is ensuring that the transmission of information is secure. And when you're dealing with one office with internet and access that you can very closely control, that is a different concern than when all of your employees are at home trying to service your clients in the banking industry, logging into some very sensitive information on their home networks. And so it's really important that we start to think about how can we secure this infrastructure with a deep understanding that financial transactions, banking is going to happen even more remotely now than it even was before. And how do we make sure that the end user is securely entering into their account, and then the back end user that's at the bank is also securely able to access that from that home environment. And a lot of this is going to revolve around access controls. And this is limiting access controls. So instead of providing broad access to individuals, the regulations really align well with this concept of you should collect the least amount of data necessary to do the thing that you're supposed to do, right? So if you are providing someone with a bank account, you do not need to have all the information under the sun about them. You should have limited information. And then in addition to that, only those individuals within your institution that have to have access to it should have access to it. So really being mindful of limiting that access is going to align really strongly with the privacy regulations that we're seeing come down the pike. And then finally, logging and getting other system feedback, especially when so many employees are working across various different work schedules. They're working in a variety of different environments. Logging what is going on in your system is so key. We're going to talk about documentation under the privacy and cybersecurity regulations, but the ability to prove and demonstrate that you are following privacy and cybersecurity best practices is going to be critical, especially during this time when we have so many different threats and so many different things that are going on. So this is a good time to take a step back and take a breather and revisit your technological infrastructure to make sure that the way that you had to very quickly spin up these remote environments is actually working in a cyber and privacy-oriented manner. Now, in addition to that, you also need to take a look at your contracts and agreements. And this is going to be really key because so many institutions are built on what we like to call this spider web of third-party processors and third-party providers. And so it's going to be really key that you take a look at those security and privacy requirements that you have in place. These are security and privacy requirements that you might have with your clients or your customers. So what have you as an institution agreed to do? A lot of that is going to be regulatorily driven, but there are things that you might have done that you said, yes, we're going to do X, and now X can't actually happen, right? We're going to make sure that there's a physical signature on a wire transfer. Well, guess what? I might not be able to get that physical signature because of COVID-19. So how am I going to authenticate that the client or customer who is signing and accepting a wire transfer is in fact that person? So making sure that the technology exists there and then communicating that so that people can understand what is going on. And like I said, you also want to be really aware of what your vendors are doing. So yes, you as an institution were impacted by COVID-19, but guess what? This would not come as a surprise, I think, but everybody was impacted by COVID-19, which means that everybody's workforce most likely had to move to somewhat of a remote work environment, right? Now, it depends on the institution and sort of what the services they are providing, but what is your vendor doing to address COVID-19 security and privacy requirements? How have they ensured that their remote environment is going to maintain the security and privacy that you feel comfortable with? Are you okay with their employees now logging in from home servers, from home email access, etc.? Are you comfortable with that? And so this is a great time to step back and do an assessment of your vendors and say, do we feel comfortable? Have they communicated to us any changes? I think if you haven't heard from your vendor that something has changed, that's the first red flag, because guess what? We have all changed drastically in the last 6 months. I'm not saying that that change materially altered the security and privacy maturity of the organization, but I think those changes are things that should be communicated across the board. And then finally, taking a look at those employee privacy notices and agreements. Your employees are often some of the most sensitive information that you are going to maintain, and you really want to make sure that you're transparent with them about the data that's going to be collected. And this is especially critical as we start to return to work and we start to do things like take your temperature, ask you where you've been for the last 14 days, things that are inherently going to make employees feel very uncomfortable and invasive, but there is a purpose to sort of asking questions along these lines. There's also ways to ask them that are going to violate the least amount of privacy of your employee. There's also ways to not store the data for a long period of time. Do you really need the employee's temperature beyond 14 days? Probably not. Do you really need to have where they went in the last 14 days for the next 5 years in your system? Probably not. So rethinking and being really critical of how are we going to get to the end result, which is ensuring to the extent possible that we create a safe work environment. It's really going to have to incorporate privacy into how you're asking the questions and then how long you retain the data. And just in case you weren't aware, there are already COVID-19 related lawsuits that are out there. We see them across the board. Some of them are not related to cyber and privacy. They're more related to access to finance, debt relief, bankruptcy, things that you probably would not be shocked to see that there's already lawsuits on. There are lawsuits, though, around employment, around the collection of data. We see that often in the European Union. There's lawsuits around education. We have seen a lot of data be collected in education because now all of these students are in virtual environments, and so there's a lot of data collection. And then event cancellation, service disruption, et cetera, and it goes on. And we're only going to see this list increase as people start to be able to take a breath after sort of the initial phase of COVID-19 and just start taking a look at it. So the short end is that we see COVID-19 liability probably extending pretty far into the future, and the impact on cyber and privacy is right there with it. So I'll turn it back to Rebecca to walk through the documentation and training components.
So, to piggyback off of what Jordan has been talking about, all of the documentation and the requirements around what you are doing. If it is not documented, it is not done. And that's what, we see this over and over again with financial regulations. But one of the bigger questions right now is, have you gone back and looked, right? Our world has changed. And it's not just that I am working from home, and it is not just that, I can't go out without a mask on. Your entire, the way we do work, the way we interact with the other human beings has fundamentally changed. And I hate the expression the new normal, but I'm going to use it anyway. But it is a new normal. And with that new normal, or with that normal, right, these are our lives for right now. And going to be our lives for the foreseeable future. And, no amount of whining and complaining is going to change that. So what we need to do is go back and say, okay, do our documents, do the things that we are going to use in the event of a data breach, in the event of an investigation, in the event of a complaint from an employee or from a customer about data collection practices, have that all been updated now that we're doing it totally differently than we've ever done it before? And some of the things you need to go back and look at are things like your remote work policy. My guess is when you wrote it, you were not envisioning you were going to have an entire remote workforce for an extended period of time the way we have. Now, I understand a lot of people have gone back into those office environments. However, a lot of them are still working remotely. Either companies have agreed to do that, and I can't remember whether it's Twitter or LinkedIn or Facebook or one of the social media guys. They're like, oh yeah, you guys are just out. You can be out until 2021. We're not going to give you a hard time. But a lot of companies are doing that, and a lot of companies are reevaluating, do we need brick and mortar to work? So I don't know that your policy now matches up with what you're doing. And that gap between what you're doing and what your policy talks about, it creates a liability. So one of the things you need to go back and do is, have I updated my remote work policy? Because everybody's working remotely now, and there may need to be changes and tweaks to that policy to address the way we are now functioning as a business. What about your bring your own device policy? A lot of organizations had a BYOD policy. They allowed their employees to bring their own device or use their own devices. Well, in light of COVID, some of the organizations have said, you know what, that was fine for when it was like one-off, but now that people are out for a longer time, and who knows, maybe out forever. We may decide that this is in fact a better way for us to do business. It's more streamlined, it's less expensive. Look, everybody can get on these calls and nobody, we struggle, but it's not a huge, struggle anymore. So what does that BYOD policy look like now? Should we change it? Should we not have a BYOD policy? Should we be rolling things out more gradually? Your business continuity and disaster recovery plans, you just ran a real life disaster recovery. You just did this. So now going back and saying what worked, what didn't work, what could we do better? Where did we fall down? Where did we rise up? What are the lessons we can learn, and how can we change it so that we're better at this? Because the goal is not to stagnate. I talk a lot about privacy and security now in the time of COVID, and one of the things is we have to get past this just surviving. We need to be thriving. The only way to thrive is to look back and say, well, what did we do well? What did we not do well? How can we improve? Constant improvement, constantly working towards that, but updating your policies to reflect that. Because the other issue is you're not all in a brick and mortar environment anymore. And so therefore, your business continuity and disaster recovery plans also have to change, because you're going to run it a little differently remotely than you would when you're face to face. Phishing awareness and prevention is a huge issue right now. As I said before, enormous, like 160% or 150% uptick in phishing emails. And so having that be a real awareness and doing training that works, right? And that's really key. Because if you're not doing training that works, you're required to do training anyway, but what is the point, okay, if people are still going to click anyway? And the other thing is you need to remember, because I can't just pick up the phone and call Joe in IT right now, who's just down the hall. I actually have to call him at his house. I have to call him, I have to call a different IT because we've outsourced it now. We've moved completely to the cloud, because that's, whatever the case may be, you need to update that and make sure your workforce is aware. And as I said before, training is critical. I love organizations that are like, we train all the time, and yet our employees still click on the email. And I say to them, with all sincerity and love in my heart, are you doing it the same way over and over again and expecting a different result? Because when you have this lack of interaction with the individual who's working with the training, when there's not the ability to ask questions and engage with your audience, is it really effective training, or have you just checked the box? Because in this area, checking the box is not where you want to be. And I know that you all know this, right? Because checking the box is great, but if it doesn't advance the ball, then why are we doing it? So training on all of these things after you have updated them is critical, but really effective training is the most critical thing you can do. And having employees just watch a video that they've seen 50 or 60,000 times before is probably not the best way of doing that. So I'm going to turn it back over to Jordan to do a few of our key takeaways.
Thanks, Rebecca. And yeah, I was just thinking, we often like in our trainings to put cartoons and some funny clips, because I think keeping people awake and engaged is always a strong goal with any training, and especially in cyber and privacy. But so what are the key takeaways and things to be looking at in the remainder of 2020? So the first one is understand the changes to your workflow. We've mentioned throughout this presentation, the remote component is so new to so many of the organizations. It is something that we are all grappling with. Fortunately, XPAN was virtual before COVID, so what is that, BC? So we were fortunate in that respect, but it doesn't mean that there weren't challenges and changes to our workflow that we had to sit back and look at. And in addition to understanding your workflow, what does your data flow look like? Because most likely your data now flows differently. And data is really where cyber and privacy liability and challenges are going to come about. So stepping back and remapping that architecture and doing that exercise of what has changed, have we had to use new vendors, et cetera, is really important. And that leads to our second takeaway, which is re-examine your vendor relationships. Third-party vendor management is one of the most challenging areas that we see currently in the cyber and privacy context. It is really hard to address all of the vendors that you're most likely using and to ensure that they are upholding security and privacy. And part of that is that while security and privacy to all of us sitting here feels like it's been around forever and everyone should be on the same page, there is so much discretion in what it looks like to be secure and private oriented. Part of that is because we don't have regulations across the board that all align. The other challenge is a lot of the standards when you're looking from a legal perspective is reasonable security and privacy. And I'm going to take a guess and say that our collective reasonable cybersecurity and privacy standard is probably very different than somebody who is walking out on the street right now who might not be in this area. So it's really important that you be examining those vendor relationships, understand which ones are critical, which ones are less critical, understand which ones have access to data and to your systems, because that's going to be really key to understand. And then change vendors when you need to. I think we oftentimes get very stagnant because, well, we've been with this vendor for 20 years. Well, has that vendor been growing and evolving with you to ensure security and privacy are being met? And that leads really well into our third key takeaway, which is be prepared to pivot. I think that we all learned this lesson in March, that the world can change very quickly. It felt like at the beginning of March, every single day was drastically changing for all of us in both our personal and our business lives. But I think the ability to change, to have a handle on your systems at a deep enough level to pivot as needed is so key. And some of those pivots are going to stick, like Rebecca said. I think that there's aspects to remote work. There's aspects to sort of this new normal that a lot of employers and employees are embracing. But be ready to address new concerns and new thoughts as they come in. Are there ways we can use technology to better prepare ourselves for whatever might come next? And I can't even think about what might come next because what has come is already mentally straining.
2020 has been dramatic enough. Let's just leave it at that.
Yes. Our fourth takeaway is preparing employees for in-person work and changes to information collection. We anticipate that a lot of industries, the financial one being one of them, is going to still have an in-person component. I think there's a lot of value to in-person, even in industries that don't require it. And I think a lot of us have learned that in the past 6 months. But things are going to be different. You know, when employees come back to work, they're going to have to provide different information than they normally would have had to. They're going to have some transparency around their sort of personal lives that we typically would not have asked of our employees. And I think preparing them for those conversations so they don't walk in on day one and say, hey, we need to take your temperature. And then the employees go, whoa, what's going on? What do you do with that data? How is that going to be assessed? Am I going to be penalized, et cetera, is really going to be key. And being upfront. And this is employee privacy notices. This is making sure that they understand this data is going to be collected but only used for this minute purpose, et cetera. So preparing those employees is really going to be a key component of it. Fifth, ensure your organization does not take on additional contractual obligations. So we have really seen a lot of companies attempt to alter their contracts to fit this new environment in a way that might shift responsibility to other parties. And a lot of times in cyber and privacy, it's really about a shifting game. Not to say that law is a game, but it's a conversation. What am I going to be willing to take on, and what can I push on to my vendors or to my customers? And this is what we often call the mutual responsibility model, which is we're all responsible, but where do those responsibilities lie? And you really want to make sure that to the extent things are being updated, terms of service, privacy notices, et cetera, especially from an institutional perspective, are your obligations changing? Are you now going to have to ensure certain things are being done that before your vendor or your customer was going to do? So be very careful not to just click that pop-up in the software application that says, yep, read the terms and service, fine with the updates, because there could be material changes. So you want to be very mindful of that.
And I just, I'm sorry, I don't mean to interrupt, but I just want to point out one thing, because this has actually come up on a couple of occasions with us, with clients, is that you have to be careful, because when your organization takes on additional contractual obligations that it would not normally be responsible for, whether you're taking on the responsibility related to a regulation or anything. Go back and look not only at the contract, but go look at your insurance coverage for that, because you'll see that a lot of times there will be carve-outs that say if you would not normally be responsible for this type of thing contractually, that we're not going to cover that from an insurance perspective. So if there is a data breach or something comes up and you go and they say, well, the contract said X, your insurance company says, well, why would you're not obligated to do that. Why would you do that? And you did it because you didn't go back and read and you didn't bring in your legal counsel to go through all that. You could be taking on a enormous liability that you would not normally be subject to. So this is kind of where you see all of the things that Jordan and I have been talking about, which are the regulations and the practices combined with the vendor requirements and the contracts, and eventually with insurance as well, because that's really a big issue. Because think about, insurance companies are paying out a lot of premiums right now. They can't go on like that forever. And so you're going to start to get denial of coverage. We see it already, but more and more you're going to get denial of coverage. And this is a great thing for them to say, well, you obligated yourself to something you would not have normally been obligated for. And so we're not covering you in that regard.
And that leads nicely to our last takeaway, number 6,
yes.
which is cyber liability and privacy insurance. There's a couple of components to break down with this last key takeaway. The first is this is talking about insurance not only institutional level, but at your vendor level, because where we often see these breaches and these incidents occurring that impact the institution is at the vendor level. And so you want to make sure that they're going to have coverage to cover you in the event that something were to happen. The other aspect of this is historically in the U.S., insurance policies in this space have been written with a very cyber perspective. So it's about breach response. It's about infiltration into your systems. It's, again, very cyber related. And because privacy has been growing in prominence, not only from the GDPR, but the CCPA, as Rebecca mentioned, and then, the offhanded whether or not we'll have a federal privacy law, we see privacy sort of inserted in. But we like to caution to really read those insurance policies very carefully, because oftentimes the privacy coverage is not as comprehensive as you might think, because it doesn't align with your cyber coverage as well. And often there are carve-outs, say, for example, FTC complaints or other areas that you really need to be mindful of that can really impact your privacy coverage. And so we often will work with clients to sort of look at both of those coverages and make sure everything is being covered, because the last thing you want to do is think you have the coverage and not actually have it there.
Yeah, and keep in mind too that when you have insurance coverage, you want to make sure it aligns with your data collection practices. And sometimes when Jordan and I talk about this a lot, I say, well, it looks like this policy, they took privacy and tried to stick it into a cyber policy, which is kind of what Jordan was just saying, and it doesn't fit as nicely as you would expect it to. And so when you're looking at these policies, and when we work with our clients in this regard, we really have to look at their data collection practices. What are they doing to see, is this a coverage that's needed? What type of data are you collecting that's going to trigger these different coverages or potentially trigger these different coverages? And it's really, really important that you are reviewing the cyber liability and your privacy policy annually, and that you're doing that in conjunction with, if not a robust assessment, at least a high-level cyber and privacy liability assessment to make sure that you are really covering what you are fully covered for what you need.
And so we're now going to open it up to questions in regards to any of the cyber privacy technological components that we went over. I would also highlight that if you would like more information, our firm maintains a blog where we put out a lot of helpful information. Rebecca and I do a weekly video where you can see our wonderful faces again. You can reach out to us at info@xpanlawgroup.com and find all those resources at www.xpanlawgroup.com. So we'll now turn it over to questions.